I don't know what's happening.
Hello?
Every graduation almost every university.
Council Charles Walioli, Council Edgar Busiega. Okay. Yeah, go slow.
So I have Simuyu.
Oh, that's how far you are.
Yes. It's been a long weekend.
Simuyu Marambi,
I'm present.
Charles Walioli,
Your Honor, I'm present.
Edgar Busiega.
I'm present.
Dego Jiru.
I'm present.
Nakorenya Eric, Your Honor. Jacob Situma.
I'm present.
I have for now. So with us, my learned brother, Eugene Wamalo.
Present.
The Republic, I hold brief for Mr. Akula, who will join me shortly, and I also hold brief for Mr. Elfas Ombati. We are together with Mr. Bore, who is behind me, sorry. Mr. Bore.
Mr. Bora is watching brief for.
No, Mr. Bore is also from the ODPP. Watching brief for the ESCC. We have Mr. Mokua, Miss Kigi, and Miss Maranga.
Present, Your Honor.
Unfortunately, Your Honor, on our part, we have those orders. And we'll be seeking for an extension of time within which to comply. for reasons, Your Honor, that most of the documents, the subject of the disclosure, are intended to be obtained from the Trans-Nzoia County county offices and the various sub-county offices under it. And we have been unable to obtain those documents. To their entirety. Some of them have been obtained. I am informed by the ESCC, at least by Ms. Piggy, that letters have been written to the county secretary. At least some of them received on the 19th of, on the 1st of May, towards obtaining those documents. And the process, we believe, is ongoing to receive them. And so that for us to comply with disclosure in the manner described by your learned brother, that they be serialized, among other conditions, we'll be praying for 2 more weeks to comply. My colleagues should go first on that point because we have an application for extension or rather review of the bail terms given by your brother in respect of the sub-county offices. You could guide us whether or not we make it straight away so that our colleagues respond wholesomely, or we wait for them to respond to that issue of disclosure first.
The high-profile arrest and drama that was witnessed before or during. It's a matter that literally gripped the conscience of the nation. Majority of the Trans-Nzoia residents whose governor is arraigned before this court would be amazed that after such a high-profile arrest and drama, the prosecution is unable to comply with these course directions issued on the 20th of May 2025. And now we hear them. We hear them seeking more time in order perhaps to consolidate their designed political persecution. I will allow Councillor Macharia Njero to give particulars of our situation.
Okay, Your Honor, when you were before your learned brother on 20th, an order was issued allowing the investigating officers from EACC to visit the county offices. When you were actually very express in court that our client will cooperate. I even gave my personal undertaking as an officer of the court that whatever was required, including the presence of our client, he will be available. But there was something else that we requested the Honorable Court, that as they were visiting these offices, the county offices, that we be notified so that counsel would also be present to avoid tampering and even possibility of planting evidence. And the court was express in its orders that they do notify us and counsel be present. In fact, even the prosecution itself said that they would do that. However, Your Honor, what has since happened is that they've been visiting the county offices and specifically the accused person's offices without notifying us and without the presence of counsel for the accused. That is from 21st of May to date. And I'll give specific names of the officers who have been visiting, Your Honor, so that it can go on record. From the week of 20th of May, there was Emmanuel Arunga, that was the team leader. And he was accompanied by the following officers. There was James Ikua, there was Martin Bovi, there was Ferdinand Kiwanuka, and Mr. Arunga. Then the week beginning 25th, Mr. Emmanuel Arunga, who was the team lead, was replaced by Philemon Chepkwani. So, Your Honor, the question that begs the answer is, why would they want to visit those offices and refuse to notify us to ensure that there is presence of the accused counsel? Why? Now here they are coming to ask for extension of time. And in fact, on the 22nd of May 2025, a letter was expressly written by accused counsel to the Director of Public Prosecutions, and the letter is here and is stamped. Were they even notified of the physical offices of the accused person, where if any request they needed, they would be able to serve, including, of course, service of the documents. Now, the other question, Your Honor, we need to ask ourselves, by the time you are charging an accused person, surely you must have collected your evidence, because the drama with which they did it, he was arrested early in the morning. That was on the 19th. Statements written the same day, even charge and caution. He was hurled into the cells. Before he was even access to toilets, he was treated like the worst criminal you can ever think of. You'd almost think that he's the worst terrorist, threatening peace and security of the country. Somebody who had been responsible for security of this country for many years. Brought to court the following morning. Now they are saying that they are looking for evidence. That's not the way the criminal justice system is supposed to work. Where you charge, then now you start looking for evidence. Where you've been given time, up to that of June, we've written to them, telling them that we are ready. They don't even respond. Now they come to court and seek for more time. I mean, that's travesty of justice. And, Your Honor, what the prosecution needs to understand, they've had their day outside the court where they could harass the accused person.
Sorry, Your Honor, we object to that line. The prosecution is in no business of harassing any accused person. We don't arrest.
What's your objection?
The objection is that the line is making is not agreeable to the prosecution. We do not arrest. We do not arrest anyone. We cannot harass. Or maybe he was referring to someone else.
You're the agents of the arresting officers. You represent EACC. So we are talking about your principle, and you are holding brief for them. So they've had their day, but before this honorable court, we are equal. And one thing I have absolutely no doubt in my mind, Your Honor, is that you will not allow that travesty of justice. Judiciary is not an extension of EACC or the ODPP. That they must know. When orders are made by court, they have to be complied with. And the question I asked even last time, Your Honor, because I said I've also headed an independent agency where things are done professionally. What was this hurry of coming, arresting him and bringing him to court, then starting to look for evidence? What was the hurry for? What was so difficult with just summoning him? Write statements, collect your evidence. If you find that there's a basis of charging him, then you can bring him to court. Your Honor, don't allow that abuse of process. Don't allow it. Now, Your Honor, we have other issues that we would want to raise about the inventory and also items that were recovered from him that we want, and also dispensing with the mention. I don't know that I should make that application now. We restrict ourselves first to the issue of the application for extension of time.
Even before service.
Sorry?
You have an issue with the inventory even before they serve.
No, there are items that they collected, including his personal items, which are personal, even his certificates, which really they can't say that his degree certificate that they are going to present it here. So I want to make an application on that. Also the issue of even his firearm, they picked it. I don't know they want to use it because at least there's no charge for murder, that he has used this weapon to murder anyone. So the item that we want back, we want to make that application. I need your directions on whether we pen that issue first until we deal with the issue of the application, or whether I should make it.
For extension of time, yeah?
That's
This
right.
is your response to it.
Yeah.
So let
So-
me hear you.
Yeah.
Sorry.
Yeah, so we oppose that application for extension. When you were in court, the time that was given, they did not oppose it. They said they were okay with it.
Sorry, Honor.
So-
Just guide us. We thought on our part we made submissions on the question of. I indicated that, but I told the court that we have an application to make. That's why we have the affidavit. So initially we were telling the court why we have not been able to comply with the order of disclosure, make the application for extension yet.
I understood you to be seeking time for disclosure.
Yes, but we haven't made the application proper because we've not told you anything on the affidavit, have we?
This affidavit that
Yes.
you brought to court today,
Yes, yes,
which I've also not seen.
yes. So we have to make an application.
Hold your horses.
Just one issue.
No, just wait for this.
Yeah, it is respect to what you are reading. That
It's not been served. Now,
as a
let me,
mere affidavit,
have you been served?
You have just,
we have
yes,
We just served
It
them,
has
yes.
just been handed over.
yeah, we
to
shall
you.
deal with it.
No, but we've served now. We've just served now.
Is it attached to any application?
There
We
is
have an oral
there is
we have
no
not-
application whatsoever.
Sorry, Your Honor. I think we are complicating this matter.
Yes.
We can make an oral application before court, but we need to
Yeah.
to give facts on an affidavit. So the application will be oral, but it will be supported by an affidavit because
Yeah.
facts cannot be given from the bar. That's our understanding of the law.
You know,
We can make an oral. Let me finish, counsel. I can make an oral application on the law, but I cannot give you facts from the bar. So I need to give you facts on an affidavit. So our application will be all your facts. That's what our understanding of the law is.
you know, may I have a bite of what I placed?
Just a minute. So, Mr. Wisi,
Yes.
you understanding, what am I dealing with?
So, Your Honor, we have two things from our
On all
part.
these submissions,
Yes.
the ones you've already taken, what are we dealing with?
So we dealt with the question of not having complied with your brother's orders to disclose today.
Yes.
But we have related an application
To extend
with
time.
extend time one.
And in your mind, those two are not one and the same thing.
if you could let me just finish.
No, you will finish.
If you look at our affidavit, other than the application to extend time, I informed the court that we have an application to extend and review the orders on conditions for bail, which is this affidavit now.
Okay.
Yes. So, and I asked the court whether we should proceed with the issue of disclosure first, then go to the question of review of the bond terms, or we deal with them separately before they go to the application.
Is it tied to the issue, that disclosure, is it tied to the review? Or are they separate?
They're related,
issues?
but they're separate.
Yes.
Separate issues.
So in my mind, we're dealing with the issue of your delay to serve.
That we are done with. That they can respond to.
Okay.
Yes. And then we can have our right of reply, if any.
To that extent that
Okay.
you say that we shouldn't allow the extension for the reason that you just
Okay.
submitted.
Mr. Oviti, you have a right of response to
In
the law,
2
but
minutes.
before you do
Yes.
that,
That he has segmented the two issues. We shall deal with that issue when it comes to his purported application.
okay.
Very well. So in a brief reply, Your Honor, the threshold of charges were met when the accused person number 1 was brought before court. And therefore, there cannot be a question of arrest before investigations. There had been investigations, the threshold to charge, the evidential threshold charges brought before your brother. Secondly, just to allay the fears, in the case of Hussein, Khalid, and 16 others, Hussein, Khalid, and 16 others versus the Attorney General, this is available on Kenya Law Reports. I'll give you the citation. And 16 others versus the Attorney General and 2 others. This is petition number 21 of 2017. The Supreme Court of Kenya, in a nutshell, said that investigations and disclosure is a continuous process. And if that is correct, and we believe it is binding on both the court and us, then even after the charges, investigations in the nature of the ones we are seeking for extension are available to us. We can continue carrying out those investigations. That's our understanding of the law.
You say he allowed you 60 days to access the office?
At least 60 days, because that's why he was barred from accessing his office for at least 60 days. The headquarters.
Just to be clear, was that order to bar the accused from accessing the office, or was it for you to access the office? Just to be clear.
What do you mean, Your Honor?
My reading of the order
Yes.
was it was barring the accused access to the office.
Yes.
Was it in the same vein, stating clearly that it was to allow the prosecution
Yes.
or the investigators
Yes,
time
because
to access the office?
Yes, because the argument of the prosecution is that there are ongoing investigations, so that if you allow him to access his office, he'll interfere with our access of the documents. That's why they're arguing that we need to inform them when we go for the documents. That's the logical and the effectual meaning of the trial court.
Anything else you wish to add?
Yes. Your Honor, we have written to the county secretary towards access of those documents. There is, we believe, an interaction and communication route between the county secretary and the first accused person. It will be probable that the county secretary can inform the first accused when documents are sought from him, because there are documents we don't need to go and pick from the office. There are documents we need to just ask the county secretary to serve us with. That is the investigators. For the documents in the governor's office, which we will go to pick, and when I say we, I mean the investigators, on that day when we need to get to the office, we shall notify counsel. So
Come again with the writing to the county officer?
we have been writing to the county officers. The ESCC has been writing to the county secretary to avail specific particularized documents. And we believe that the county secretary can inform the first accused, if need be, when those documents are sought. Because it is possible that those documents can actually be delivered to the ESCC in their offices. But for the notice has to be given. We agree with the defense. We are yet to get there, where we'll be going to the county headquarters. The letter that has been referred to is about them informing us where to deliver documents. It has nothing to do with them reminding us of the notice. So that is our response in short. My senior, Mr. Kula, can add one line and then we...
Your Honor, with the learned brothers' directions, they were very comprehensive. And anyone who practices before this court will understand that the procedure in this court and the procedure in other courts are quite different. In that we disclose each and every document, you must paginate each and every document. The court went further to ask us to identify the type of evidence each witness will produce. So these directions are very, very comprehensive. In that, Your Honor, we were not able to complete them in the period given. We apologize for that, so we will be requesting for, that is the reason why sometimes we have not failed to disclose as directed, Your Honor. So we apologize for
So
that.
the delay was caused by the courts, very expensive.
They are very expensive, yes, Your Honor. And the practice of this court, Your Honor, you will understand that the directions are very comprehensive.
Because, you know, he can't make reference to that case because there was a specific order of the court regarding the compliance to try and circumvent them. They cannot have, the court could not have said that at all. So it's misdirecting the court when it comes to that. And just to mention also, Your Honor, that for purpose of emphasis, it is the prosecution that made the application and given that time which they had sought themselves, not us. And they are themselves the ones who say that they comply by that which is today, by giving us the document themselves. It was their case. Now they cannot purport now to come and start now saying that they need more time to collect the evidence.
First to a decision, either give us a proper citation so that we respond, or at least supply us with a copy. Yeah.
Then I've given citation, but I have a copy here which I can forward to him. This was my criminal law teacher at the law school.
And
I'm
that's
sending him. He was not aware it went to the Supreme Court. I'm telling you.
I told him
The
to
court
supply
has a
copies.
copy of that Supreme Court
It's here.
as
It's
well
here.
as the Court of Appeal decision. But please send us the one you
I'm
have.
sending.
I'm told nowadays AI is generated.
No. Your Honor, I hope the court is not suggesting I could use AI. I'm one of the most brilliant lawyers in this country.
Okay.
I know that.
Yes. Lucky for us, we are surrounded by brilliance.
Thank you.
Now, the only application that and Mr. Owiti, my reading of your application is that you have actually sought an extension of time.
Yeah.
That is the only application I have made, so that we're clear. There are two other applications pending in the wings. One that Mr. Owiti promises is supported by you. I want to see the formal application. So please file a formal application, attach your documents up. There is also another application I think Council Mashari is referring to, waiting in the wings. Is it possible for you to formalize that? For the reason that I have another matter for hearing, it will not be possible for me to hear those many applications and still attend to my daily course and stuff. So perhaps I can give you another date to come for us to hear those other applications.
Yeah.
But for now, let me give a ruling on the issue of delay, particularly of the discovery.
That's all.
element.
We are guided. We are most obliged.
So please take this back. Oh, no, sorry.
The affidavit can
Yeah,
stay,
Let
yes.
it stay.
Or needed to grant the prayer, then the extension must be within the 60 days.
You are preempting my thoughts. the issue that you have raised. So the issue at hand is the delay of disclosure of the evidentiary documents and witness statements by the prosecution. The prosecution states that they have not been able to give disclosure of the basis of their case, as they are still in the process of gathering documents from the subject's county and sub-county offices. In the same vein, the prosecution also states that with the information they had gathered, that they had gathered through the investigators, the threshold for the preferring of charges was met. Further, that the decision to charge was well within the ODPP's policy on the same. The application is opposed by counsel for the defendants. They state that the delay caused in the disclosure taken in light of the clamor around the first accused's arrest is a travesty of justice. The defense also protests that the subsequent visits by the investigators to the first accused office and county offices have been done without disclosing to the counsel of such visits. They are apprehensive that the surreptitious visits may be used by the investigators to plant evidence against their clients. The court did give thorough directions on disclosure. It is clear that the prosecution has not been able to do so. Although they state that they were given an onerous task on the nature of the disclosure, it is imperative for all parties to ensure that they comply with orders as strictly as possible. The rights of the accused and the interest of justice demand it from all the parties. That being said, and even taking into account the decision of the Supreme Court in Hussein Khalid and two others versus the AG on the matter of disclosure being continuous, and having reached the decision to charge, it would follow that the prosecution had reviewed a number of documents and witness statements already in their possession. Those documents and statements ought to have been disclosed by now. This is regardless of their liberty to give such further disclosure as and when it may come into their possession as the matter goes on. I therefore direct the prosecution to comply with the orders of disclosure as were made by these courts on or before the 16th of June 2025, when this matter is to be mentioned again for further orders. Both parties have alluded to several other applications which they wish to present before court. I direct that such other applications are to be formally filed and served in any event on or before at least 7 days before the next mentioned date, which is on the 16th of June 2025. Now, this date was fixed in your absence, I know. There was the second accused was to be presented in court on that day. So perhaps if there are any issues that would make it onerous for you to come to court on that day, I may hear them now and for us to consider whether we move that date.
You know, we've already agreed with the prosecution
Okay.
for all the mentions. Save of course.
No, you should not go on record that you agree.
Okay.
Yes, but you can make the application.
I have spoken to him, he said it's okay, that's why we are counsel. Why?
No.
Why do let me make the application, maybe yes, is the reason. So
Okay, just a minute before you make the application.
yeah, that's fine.
It serves for you. Okay. And for you too, Mr. Witty, 16th is okay. Okay. Now, on the issue of attendance of the accused, first accused particularly.
Yes.
Uh-huh.
Yeah, we're making an application
Yes.
that they will dispense with his personal attendance in respect to the mentions on the trial there. Because firstly, of course, it's not necessary. But as and when it's required to be a person, we are giving our undertaking that they will ensure that he
Your Honor, perhaps before Mr. Witty speaks,
Yes, Mr. Nyaundi?
I'm on record for the first accused.
Yes.
I think we have orphaned the second accused.
Mm.
And it would be appropriate because they travel the same distance
Mm.
from Kitale to Nairobi.
Mm-hmm.
And any order you make with respect to dispensation of the attendance during mentions
Mm-hmm.
also does apply with the second accused person.
Check please, yes, sir.
But is he present?
Probably not.
Within our knowledge.
Not within your knowledge.
I don't think they mentioned concern.
Okay. Mr. HS, I saw you last in court. Not here.
He's still unwell.
Okay.
That we may not oppose.
Mm.
But I then And we have the view that we could have the middle ground of, during the mentions, at least appearing virtually. From wherever he is, he could appear virtually for the mentions.
So is that in respect to both accused
No,
or only the first
That
accused?
is in respect of the first accused. We are not able to make responses in respect of the second accused
Okay.
because it's yet
To take plea.
take plea.
The second of the first accused at the next mention date. We'll be dealing with it on a day-to-day basis. So when we call for the next mention, then we'll see whether it will be necessary for him to attend or not. But for now, he does not need to attend on the 16th. Mr. Nyaundi and Mr. Chisa cannot give directions also for the second accused. He's here to take plea. So strictly speaking, not under our jurisdiction yet. Okay. So I think we are done with this matter. We'll see you on the 16th.
We are most obliged.
We'll talk later.
Hapa ndio wataleta drama mbaya sana. Wewe
unatembea.
Ndewa. Umemaliza?
Nachania hapo. Hapo ndani. Na wanashika akina nani hawa?
What's wrong? No, what's wrong? What's wrong?
Just tell us reason for arrest.
What's wrong? What's wrong? What's wrong? Tell him reason for arrest. What's wrong? What's wrong? What's wrong? What's wrong? What's wrong? What's wrong?
Why are you arresting him?
They want to kill us! Ruto wants to kill us! You want to kill us! Ruto wants to kill us! Ruto wants to kill us! We are not threatened! We are not threatened! We are not threatened! We are not threatened! We are Kenyans! We are Kenyans! We are Kenyans! We are Kenyans. Why are you? No. Don't joke with us. We are Kenyans. This is our country. We are not the Hungarians. What are you doing? This is our country, Kenya. Ruto, you will not kill us. Ruto, you will not kill us. We are not threatened. This is our country, Kenya. Why are they ambushing people like this? This is our country. This is our country, Kenya. This is our country, Kenya. This is our country, Kenya. We have freedom of speech, freedom of doing anything, according to the constitution and the law of Kenya. I am speaking the truth. This is our country. Kenya is our country. We must not be sabotaged. We must not be arrested. We must not. What is happening actually? Why? Ruto! Don't kill us! Don't kill us! This is our country. This is our country. This is our country. This is our country.
Some of us came prepared to represent both Governor Natembeya and Rose Njeri, a very young lady doing what every Kenyan should be able to do, have open conversation about the state of governance in our country, and just attempting to have a conversation about Finance Bill 2025. There's nothing criminal about it. She has been apprehended and we don't know where she is. So we must remind the DPP and William Ruto that if you still believe this country is under the rule of law, please produce Rose Njeri with immediate effect and be able to face the consequences of acting against the Constitution. You know, you cannot hold an accused, a suspect for more than 24 hours before producing them in court. This is the basic law of the land. And kama mulienda kule Homa Bay na munasema kwamba you have apologized to the agencies, how do you apologize to the agencies and you continue to harass them? So some of these things we are going to be dealing with. We are very clear about it and we will not relent. Kenyans will not surrender. We've just seen one frustrated Kenyan here expressing his complete sense of despondency. We cannot afford it in our country. Maybe my friend Eugene can talk to you about this matter.
Yes, just to say yesterday was Madaraka Day,
Yeah.
and there can be no greater Madaraka for any Kenyan than the Madaraka to be able to participate in decision-making systems of your country, including the budget-making process, including the finance bill that will determine what happens in this country. Rose Njeri is one of the heroes and heroines of this country that we need to celebrate, not to incarcerate, not to harass, because she was facilitating public participation. And in her own very ingenious way, in a very creative way, she had facilitated many Kenyans to interact and to participate in this budget-making process. And particularly noting that 25th of June is coming. Today is 3rd, meaning we only have 3 weeks to the next Revolution Day, the Liberation Day of Gen Z's, 25th of June 2025. The Finance Bill 2025 is coming. And as Kenyans, we are allowed to participate in the making of that bill. So we are here to demand, we're a big team of lawyers here. We were ready after the Governor Natembeya case to stand with Rose Njeri. She has been held at Pangani Police Station for several days. We had been told she'll be produced today as we speak. She's not in any of our courts. Where have they taken her? Why are they holding her? What crime has she committed? These are the questions we want to ask today. Even as William Ruto apologizes to Gen Zs, he must start by releasing and apologizing to Rose Njeri. She has done nothing wrong. From Trans Nzoia, I want to say this. We've seen what has happened today. A prosecution that has no evidence, that is set on a fishing expedition, that did a lot of drama raiding Governor Natembea's homes in Kitale, in Nairobi, in Rongai. They brought him here, and they have no evidence. They are now harassing anyone, whether family, whether politically associated, whether working with Governor Natembea. We have seen them harassing people here who travel all the way. We are saying this harassment must stop. This harassment, this is pure political harassment, and we demand that it stops. Thank you very much.
Well, just as June the 3rd, we declared that June the 25th will be a public holiday to commemorate the singular struggle by the Kenyan Gen Zs, who have actually raised the conscience of the world, not just the region, the world. So for me and all of us in opposition, we are very clear that 25th will be a public holiday. And then the police, why keep Njeri? You could even have given her a police bail. Now you are complicit in this heinous crime against humanity, because she's a human being. She's a Kenyan young lady entitled to all the freedoms under the Constitution. To the people of Trans Nzoia, we are with you.
Thank you. Santin.
A Kenyan citizen, Kenyan patriot, and I stand here in solidarity to defend our people. I'm not happy with what is happening in the Republic of Kenya, especially with unlawful arrests, victimization, intimidations, harassments that are occurring now and then. This is our country. Let us respect our constitution. Our President, His Excellency Dr. William Samoei Ruto, had to swear 2 oaths, first oath and the second oath. He must be able to protect our Kenyan constitution. He must be able to protect the entire citizens. But what is happening in the Republic of Kenya actually is very horrible. Now, once it continues like this, are we going to encourage the local investors? Are we going to encourage the international investors or foreign investors? This is very bad. Now, what about to a local mwananchi? Someone who is voiceless, someone who doesn't have anyone to defend him or her. Where shall he go to? This is our Republic of Kenya, and I'm speaking the truth. Leadership is very much unpredictable. Today you are the president. The following day there is another one who will be leading. What will happen now? Maybe if the following day or the following year or the coming 2024, then another person who will be leading will be your enemy. Actually, it's not good, and that is what I'm really clarifying. We want peace in the Republic of Kenya. Thank you very much. I'm Paul Wamaru, a Kenyan patriot and a native of Kenya.